Steve Baker and his attorney Bill Shipley join us. Steve, I hate to do this to you, but we've got about 6-7 minutes. So why did you plead guilty?
It was no more complicated than this. Last Wednesday was my pretrial hearing, and the government basically went into lockstep deny mode. That was lockstep with the court itself. The last minute hopes that we had that they would either grant us a dismissal of my case based on selective prosecution, or they would at least grant a continuance, which would mean that during that time they would also give us the discovery that we had requested on the some 80 to 100 other journalists, media influencers, podcasters, bloggers of all types of media that passed through those restricted spaces and into the Capitol that day, why they weren't charging them. And when the judge laid down the law and said no, he was going to just basically show his inflexibility. And I thought, you know what? After that, then the trial is nothing more than a shaming exercise if you're not going to be allowed to present your own case.
Right.
So, and I think Bill can speak to that a little bit more clearly.
Bill?
Well, Steve and I had a conversation, and ahead of that hearing, and I said, Steve, based purely on the facts, I think we can defend this case. But at the end of the day, particularly during that pretrial conference hearing, it became clear that the government was going to use 4 comments that Steve had made over the course of the day to, in effect, show that Steve had, in the government's words, joined the mob. In other words, Steve was, in some respects, taking the government's interpretation of his words, he was applauding the conduct of the crowd that day. And the government said that sets him apart from the other 80 journalists. Well, you think about that. That basically says any opinion journalist whose opinion is on the wrong side of what the government deems to be the line of acceptability is therefore subject to prosecution.
Correct.
And as long as your opinions are on the right side of the line of acceptability, you're fine.
So that's a First Amendment right.
Exactly, but we could not get the court to accept that. I think part of what we were up against was these were only misdemeanor charges. The court was simply not going to give us the evidence that we thought we were entitled to. Part of the difficulty of that particular kind of defense is it's almost a concession that you've actually committed the crime, and what you're saying is why aren't other people similarly situated being charged with the same crime?
Correct.
So it's a double-edged sword in that regard.
Right.
And after the election, it was just a matter of, Steve, we can get out of this in such a way where we write the facts. We decide what we tell the judge were the facts of the case. Unlike a plea agreement, when you have an agreement with the government, they write the facts and you're stuck with them because the alternative is go to trial.
I will tell you that I pled, I don't know if I pled guilty. I might have. Pled guilty in a case, had to surrender and just acquiesce on a case years ago involving terrorists. And I had them dead to rights. But the government was controlling all of the strings and all of the information. And if you can't get the information from the government that they have and that exists because you have copies of it, but the judge says, no, I need to see the official copy, and the government says, well, we're not going to give you the official copy, you have no place to go. They win every time if you can't get them to cooperate in any way and give you the information that they only have. That's what you're fighting, right?
Yeah, and our alternative here would have been to go to the appellate court, but we could only do that after the district court, the trial court, after that case was over. We could go to the appellate court, but again, we're talking about 4 misdemeanors. How much effort are you willing to put in to go to the appellate court to try to get this information that the trial judge has denied you?
Okay, so what's your sentence going to be, Steve? Do you know?
Well, they set my sentencing hearing for March the 6th. Now, we don't know, but the judge himself acknowledged in the court date on Tuesday that we likely would never see each other again. How about that? He actually acknowledged that, actually said it twice in reference to the fact that there was going to probably be pardons coming down and therefore I would never be sentenced. But in that moment, I think the judge made a really critical and unforced error because he decided to go ahead and dress me down as he would normally do during the sentencing hearing. And since he decided that we probably wouldn't be able to have that hearing in March, he was going to go ahead and take that opportunity now to chastise me. And what he did, Glenn, it was incredible. And we're going to have the transcript of this, and we'll certainly release it through the Blaze, is that he dressed me down not for my behavior, but he criticized my actual work as a journalist because I had used the terms weaponized DOJ, and I had been critical of the biased court.
Wow. Wow. What a violation of your First Amendment. All right, guys. Steve, thanks for explaining this. Bill, best of luck. Keep us up to speed. I think you are right. I think Donald Trump's going to come in. And I hope not for everybody. I mean, there were some people that were really bad actors in this, but most people weren't. And that should be erased from their record entirely. Thank you, Steve. Appreciate it. God bless.
Glenn.
You bet.